Hi there and welcome to ET Now. I'm Ashwin Mohan and welcome to our special show, Green Light for Tata-DoCoMo, where we're going to analyze over the course of the next half an hour the various repercussions, implications, pros and cons of that crucial and much awaited verdict that came in from the Delhi High Court on the Tata-DoCoMo spat. What the Delhi High Court has done is that it has accepted the consent terms filed by both the parties, and that means that that billion-dollar arbitral award, which came under a lot of controversy and was passed by an overseas London court, is now enforceable in India. That's not all. The RBI's intervention application has also been rejected by the Delhi High Court. So what does this crucial verdict mean for the parties involved? What kind of a precedent does it send for such kind of joint venture contracts? What does it mean for contractual obligations? And what's the stern message that has been sent to the banking regulator, that's the RBI? To throw more light on all that and much more, I'm joined by three very special guests. Senior lawyer SP Ranina. Joining me in the studios, of course, is Nirav Shah, partner DSK Legal, and I'm also joined live by Amit Tandon, MD IIAS. Nirav, I'm going to kickstart the show with you. A very, very important order that has come in. A lot at stake, not only for the parties involved, but also, of course, for various other corporates that have entered into such contracts. What's your initial reading of this order? Clearly, it's going to be welcomed by India Inc., right?
Absolutely. That goes without saying that it would come as a huge relief for the corporate India, especially DoCoMo entity and Tata Sons, because it kind of completely puts to rest the controversy with respect to the payment of money by Tata Sons to DoCoMo. What was surprising, in fact, was that the position taken by RBI before the Delhi High Court for intervention, which in more ways than one was probably misconceived, because the given setup, the proceedings that were pending before the Delhi High Court, there was no scope for a third party to intervene in those proceedings. So from that perspective, the verdict of the Delhi High Court dismissing the intervention application of RBI is actually a landmark position taken by the Delhi High Court.
All right, landmark order coming in from the Delhi High Court. That's the initial word from Nirav. And Amit, why don't you come in over here? Do you concur with Nirav that it's a landmark order and perhaps, you know, it puts to rest a lot of uncertainty that surrounded such contracts?
Oh, absolutely. This is a landmark judgment, and at the end of the day, you need to remember that in this case, after the initial hesitation, Tata's said that they are willing to pay. DoCoMo had filed a claim, or rather claimed that, look, Tata's need to buy about 26.5%, which they held the DoCoMo shareholding in their Indian venture for about around 7,500 crores. Both the parties agreed that one said that this claim is, we have this claim on you, the other said yes, it is payable by us, and at which point the RBI came in and said that, look, we don't think this payment should be made. And there was a little bit of toing and froing, because the RBI had first written to the finance ministry. The finance ministry said RBI needs to take into account the applicable law and give the judgment. But look, at the end of the day, both the buyers and the seller were in broad agreement that this payment needs to be made and were willing to make it. And in that context, it kind of should bring to rest some of the concerns which investors have had with this regard.
All right, so investor concerns will be assuaged. I'll quickly move on to HP Ranina also before we shift focus to the nitty-gritties of the order and also try and get a better sense of some of the major legal takeaways. Mr. Ranina, you've heard out both Nirav as well as Amit. Your initial take on today's order from the Delhi High Court, sir?
The Delhi High Court judgment now very clearly says that Reserve Bank's objection is not valid, and therefore the award given by the International Arbitral Tribunal in the case of Tata-DoCoMo should be implemented, and Tatas would be free now to pay the money to DoCoMo as per the settlement which they have reached. So I think this will have a great impact on several such international cases which are pending in various high courts. Unless the government decides to go in appeal from the single bench judgment of the Delhi High Court to the division bench and thereafter to the Supreme Court. The other alternative is for the government to come up with some guidelines as to in what circumstances the foreign arbitral award can be given effect to. so that it becomes applicable to all the pending cases which are in the pipeline and the judicial process comes to a halt. The government wants to improve the climate in India for investment, and if they want to therefore really encourage investors to come to India, to make in India, then they have to now permit these type of commercial arbitrations to succeed, because in the bilateral investment treaties it is now being made mandatory that all arbitration will be done internationally and not done in India.
Point taken, Mr. Ranina. Initial observations in from all our special guests. And now, Nirav, let's look at the nitty-gritties of the order. I've read the fine print of the order, and there are 2-3 issues which really stand out. One is, of course, the stern signal given by the court to the to the RBI. And let me quote from the order. The order says that there is no provision in law which permits RBI to intervene in a case like the Tata-DoCoMo plea. It also says that RBI cannot seek nod or permission for enforcement of an arbitral award if it's not a party to the case. So, is this a case of RBI perhaps barking up the wrong tree, Nirav?
So, there are 2 issues involved here. The first one is the position taken by RBI before the Delhi High Court was on the point that the particular clause of the shareholders agreement whereby Tatas had to buy out DoCoMo at a particular price. The argument was that that particular clause is bad in law, and that was primarily their objection for this enforcement. The position taken by the parties, that is DoCoMo and Tata, is that this money is not being paid towards share sale. The money is being paid towards damages. And if that is the case, there's really no question of the clause being violative of either the FEMA regulations or the Contract Act. So to that extent, I think RBI's argument itself was flawed. So that, as far as that is concerned, I think Delhi High Court is absolutely spot on. So the second part of the question?
The second part of the question was the fact that the Delhi High Court has also said that RBI cannot seek nod or prior permission for enforcement of a arbitral award wherein it's not even a party to the case. In this case, it was seeking to be a party, but that was rejected.
So that actually is a fairly settled position. Any third party to an arbitral dispute cannot intervene in the manner which RBI tried to seek here. At best, what RBI could have done is, instead of intervening in this matter, they would have waited for a High Court verdict to come in. When Tatas would have had to apply for remitting the funds to DoCoMo, at that point of time, they could have taken whatever objections they had to take. And probably, I don't know if they stood a chance at that point of time, but whatever little hope they had, they could have had achieved at that point of time. But intervening before the Delhi High Court, to my mind, was a non-starter.
All right, premature and a flawed argument. Yeah. You know, Amit, I want to get your thoughts in over here. You've heard out Nirav. And another aspect of the order seems to deal with the fact that there was absolutely no opposition to the consent terms. And perhaps the only party that could possibly oppose was Tatas. And the Tatas had clearly said that we have absolutely no issues with the consent terms. Now, do you think that this is a stern message from a High Court of the land to a banking regulator that you cross the line and you cannot really intervene in what is essentially a private pact and private consent terms? So a line has been drawn with this judgment, Amit?
Well, yes and no, because RBI did say that while there isn't any basis for them to intervene in this matter, they did point out that they were doing so under the FEMA regulations, and therefore at a broader level they have to look at what the FX position is. But I would at this time want to make a slightly different point, which is the fact that, look, at the end of the day, you need to look at, the regulations might have initially been put in place to say that, look, companies don't misuse the provisions of the law and kind of try and remit money outside. And therefore, by way of over invoicing or overpricing the shares, sell it to someone and then take money overseas. But this is not something which we needed to fear in this case. It's Tatas did have the ability to remit money from any of the companies anyway. So they've just felt that, look, there is an agreement under which they need to pay the money. They were happy to pay it and said, please let us pay the money. They could always, you remember, they have a lot of entities out in London and in other parts of the world, and they could have easily found money in some of these places and paid DoCoMo. The second is that, again, DoCoMo is a large listed entity. They would not say that, okay, we're going to charge you 22 or 32 rupees a share, and then we are going to give you something on the side. So I think at all levels, this would what in our parlance we say the smell test. The transaction was passing the smell test, and therefore in that context the intervention by RBI I thought was a little bit unwarranted at this stage.
Amit, there's another aspect that has been highlighted by the Delhi High Court, and this is something from the fine print of the judgment, and this is a finding wherein they are saying that the RBI has in fact no right, and it's not open to them to recharacterize the nature of payment of the arbitral award. How significant do you think this finding is? This also sort of limits the RBI's powers when it comes to sort of flexing its muscle in such kind of contracts, doesn't it?
Sorry, who's that question directed to?
Amit, that question
I think
was
the
for you.
lawyers are better off commenting on that.
All
okay,
right, so
I thought the lawyers are in a better position to comment on something like that, but on the face of what you're saying, I kind of agree with you that there is a certain scope for which on which RBI can intervene, but they cannot kind of step in at each and every stage of what is essentially a bilateral agreement between two consenting parties.
Yes, Amit, just hold on to your thoughts over there. I'll post that question to the corporate lawyer on the panel. What do you have to say about the fact that the RBI cannot recharacterize the nature of payment? Is that another aspect wherein the Delhi High Court has laid down the law of the land? Or is it something that already existed and has merely been reiterated in this order?
Yeah, so to my mind, I don't think it has examined that aspect from a legal perspective as to is this a recharacterization of a payment. I think the only argument that RBI made was this is essentially the money that is being paid by Tata's to DoCoMo to buy back their shares, which argument has been completely negated by Tata's argument that look, essentially what we are paying is the damages. that DoCoMo has suffered. So the entire argument actually was kind of turned on its head by Tata's, that it's not really what RBI is saying, and the ground for RBI's opposition was just that. And by saying that this is not really what we are saying, it's a money payable towards damages, I think the whole argument of RBI essentially was negated.
All right, before we move on to the observations on RBI to some of the other aspects of the fine print, help us understand what was the anxiety of the RBI. What was it fearing? Because the RBI kept saying that if we allow this, it will set a wrong precedent. So put yourself in the shoes of the banking regulator and help us understand, and also our viewers, what was their major concern?
So to my mind, one of the major concerns of RBI would have been that by this mechanism, parties are trying to avoid the pricing formula that is currently in place under the FEMA regulations, that if you want to, if a resident wants to transfer a share to a non-resident, it has to be done at a certain price level. And if these monies that are being paid by way of damages, and actually you're just characterizing that as damages, but essentially you are doing that to acquire the shares of DoCoMo. So I think their concern would be that such a position can be misused by all joint venture parties, and monies could be taken out of India under that pretext. So I think that may have been RBI's primary concern.
All right, Amit, I'll pose that question to you again. What do you think was the RBI's primary concern? And their intervention application has been rejected by the Delhi High Court. Do you think they even have a strong case to try and appeal against this order at the Supreme Court? All right, I'm now going to pose the same question to Mr. Ranina. Mr. Ranina, do you perhaps think that after this order, there's also a signal to the government, in fact, that there is a lacuna or a gap in the FEMA law, and the government perhaps needs to take a cue from this judgment? Your take?
Well, obviously the government has to walk the talk, since they have been talking about making it easy for people to invest in India. If they want ease of business in India, then one of the important ingredients is that they should permit foreign arbitral tribunals to be implemented in India, and those awards should be considered to be binding, so that uncertainty is eliminated once and for all. So what the government, in my opinion, should do is to come up with proper guidelines and make it mandatory for the for the implementation of the awards given by international tribunals, because that will put a lot of confidence in the minds of foreign investors. International arbitration is very important today in this world, And if you allow those awards to be implemented and to be executed in India, then that will bring a lot of confidence to foreign investors.
Mr. Ranina, will this order also set a precedent in the sense that it sets a benchmark of sorts for the usage of put and call options in commercial transactions? So in that way, is this a precedent setting order?
Yes, it shows that to some extent the RBI was not correct in its legal stance, and therefore now the High Court says that you are free to do it. So if you are free to do it, then everything is legal, and what is in the pipeline has also become legal. Therefore, there is nothing for the foreign investors to worry about. And unless the government, reverses the Delhi High Court decision and comes up with certain legal framework which is contrary to what has been stated by the Delhi High Court, that's a different issue. But I don't think the government will even think of that line of action. They will want to fall in line with the guidelines laid down by the Delhi High Court and make, use this as an opportunity to streamline the foreign exchange management rules and regulations.
Right, Mr. Ranina. Amit, what kind of a lesson do you think this Delhi High Court verdict has for other corporates who are perhaps involved in similar joint ventures? Does it mean greater due diligence? Because, when this arrangement was struck, clearly both the parties did not know that the law will, change at a later date. And that's something that nobody can predict. But what's the key takeaway from today's verdict for corporates?
Sure. Before that, I just want to come to the previous point which was raised, which is the fact that, does it clear the way for put and call options? I'd kind of not be so unequivocal and say that this will happen, because at the end of the day, as you yourself pointed out, one of the arguments which was put forth by the Tatas was that, look, it's not so much as the price per share, but the fact that this is damages which are being paid. And therefore, if that is kind of something which is overriding principle, then, we can actually come back and say that put and call options still need to kind of, it will take some time. Coming back to the other question which you raised, look, at the end of the day, when people are coming into the country, it is incumbent upon them to be very sure in terms of, who their joint venture partner is, what is the track record they have, what is the credibility, have they been honoring their commitments, let alone the other foreign joint venture partners, but with regard to banks and the other institutions. So it's a part of the due diligence. Here, of course, they had the Tatas, which had a lot of credibility, continue to enjoy a lot of credibility. So you could say that, look, yes, we trust these people that they will do something right. And that is something which all the foreign companies coming into India and looking for Indian joint venture partners need to say that, look, do we have a partner whom we can trust? Are we in a position to continue to do business with them over an extended period of time? If there are some differences, would they be fair to us, and is there a way of kind of easing what has happened between the two, and is there a good exit? And this is, while it's true for foreign companies coming into India, it's also true about Indian companies who are looking at foreign partners, that look, what is it that they're bringing to the table, and again, is it someone or some company which they can trust and some management they can trust?
Right, Amit. Now, at the heart of this entire issue is the FEMA regulations. And, when it comes to the FEMA regulations, the order from the Delhi High Court also has several observations. And one of the observations says that the Tata-DoCoMo shareholders agreement was not opposed to any Indian law, including FEMA. But here's the interesting bit. And here's wherein I think the Delhi High Court has, cleared the air to a certain extent and said something in black and white. This statement is extremely important. FEMA contains no absolute prohibition on contractual obligations. And Nirav, here's where I want you to get your views. How important do you think this statement is? Was this clarity required? And also, don't you think that if this does get upheld by the top court of the land, which is of course the apex court, then it will provide a great deal of flexibility to such joint ventures?
I'll take your second question first. To my mind, I am not so sure if they will take it to the Supreme Court, because there were essentially three parties here.
Before you answer the question, I want to ask you, if RBI filed an intervention application at the Delhi High Court and that intervention application itself has been rejected, which means it wasn't a party, it wasn't heard,
Precisely.
Is there any locus standi for it to approach the Supreme Court at all?
None. So that's what I'm saying. So to my mind, their ability, RBI's ability to challenge this order is really low. I mean, you never know. They can still challenge it, but it will be very difficult for them to convince the Supreme Court that they have a locus to intervene, and they would want the Supreme Court to hear them on these issues that have been decided by the Delhi High Court. I find it too far-fetched. So that to my mind is the case. As far as your first part of the question is concerned,
no absolute prohibition.
Yes, there is no absolute prohibition. From time to time, whenever any issue arises under a contract in a joint venture and any payment has to be made, certain payments which can be made on an automatic route, certain payments that will take RBI approval. So it really is on a case-to-case basis, and there is no blanket rule as such that all payments are allowed or no payments are allowed. There's no such blanket rule as such.
All right, time now indeed for closing comments. And Amit, the court has also taken cognizance of the wider ramifications of such disputes. And, the court has said that when it comes to an Indian entity, and here's an Indian entity, which is involved in a pact with an overseas entity, and that overseas entity expects the Indian entity to honor its contractual obligations. And the court has said that if that necessarily does not happen, then that could impact FDI flows. It could also impact diplomatic relations, in this case between India and Japan. So in that, that scenario, that's been really spelled out well by the Delhi High Court. So would you say that the Delhi High Court has sort of recognized the commercial realities on the ground vis-a-vis the ever-changing policy?
Oh, absolutely. You kind of look at this case, if you go back a little bit and look at, again, another telecom company, Vodafone, where there was a retrospective amendment. All these conversations actually dominate boardroom discussions overseas when companies think about what their strategy vis-a-vis India is, and whether they should be investing, should they be looking at a joint venture partner. And a decision such as this will bring a great deal of clarity to them when they are thinking about the Indian market. And as you say, it is bringing a great deal of clarity to commercial decisions which are being taken, provided this is upheld and is not appealed in the Supreme Court, and we don't see any kind of reversal of the order by way of certain retrospective amendments. Having said so, it's always good to have a framework, and what you also want to do is whether the framework is right, wrong. You could argue whether it has some merits or demerits. What people don't like to see is frequent changes. So if there is a framework and there is some clarity that, look, it's going to be there for 8 years, 10 years, 15 years, foreseeable future, that is what investors and corporates are looking for when they're wanting to invest. And that's true, again, not just for companies, foreign companies investing in India, but equally true for Indian companies who are investing in other countries.
Right, Amit. Now, I have time for just one last legal aspect that has also been highlighted by the Delhi High Court, and that's the fact that, parties to an arbitration award may enter into a settlement or consent terms even at the time of execution of that award. Nirav, what's your take on this particular finding by the Delhi High Court?
So this actually has been a settled position, and right. I don't think there's any new law that is being laid down as such.
So they've reiterated an earlier settled position?
Yes.
All right. So I'll leave the last word to Mr. Ranina. Mr. Ranina, do you think it's time now for the Indian government to have a relook at the FEMA regulations, perhaps make them a little more friendlier in a globalized economy?
Yes, not only make it clear and comprehensive, but make them investor friendly. I think the investor friendly regulations are most important today, especially with many other countries taking protectionist views. If India can project itself as a more open and liberal economy, then we will get a lot of investments into this country. So we have to make our rules which are investor friendly. And that is what the government should now immediately get its work done in this context, and give the right signals, the right message to the world.
All right, so a relook at the FEMA regulations, that's the need of the hour, and that's the final word coming in from HP Ranina. And of course, during the course of the discussion, several interesting aspects that have been highlighted. The fact that the RBI has been told that they cannot intervene in an arbitration case where they are not a party. The fact that perhaps the RBI doesn't really have too much of a strong case to appeal this order at the Supreme Court. And finally, of course, the entire FDI aspect, wherein if you're an Indian party, you are expected to honor your contractual obligations, and if you don't, then that could impact FDI inflows. So clearly the Delhi High Court has taken the law of the land into perspective and also commercial realities into perspective. On that note, I must thank all my guests, Mr. Ranina, Nirav Shah, as well as Amit Tandon. Thanks so much for taking out time and thanks for tuning into the show. Stay tuned to ET Now for more news and updates.
Find us on Facebook at facebook.com/etnow and don't forget to click the like button. You can also follow us on Twitter at etnowlive. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/etnow.